There are only two of you here. Before we start, do either of you have any questions that you would like me to address? Your internet is likely to drop out 44 times. Okay. Sorry, Erin. I saw Clay shaking her head. She has no questions. She is completely on top of everything. So my plan is to pick up where I left off in class last week and continue on through express terms and where you find them in agreements. So unless, and please do stop me as I go, though it might be hard for me to see you, so you're going to have to turn your microphones off and talk to me if you need me to stop and talk about something. But my plan is to share a screen and talk to you. So I think, no. Can you see my slides or the blue side? Awesome. So this is basically where we picked up. Let me just see if I can do it with my fuzzy thing. Yes, I can. Awesome. All right, so we're talking about the contents of a contract and where we find the contents of a contract, and in particular, express terms. So we've already sort of gone through the rationale. We've been talking about them in terms of, okay, for some reason now my family are texting me. I'm just going to just turn the phone on silent. If something goes wrong, it's over there. They will come in. Like, really? Okay, so we've talked about objective testing in particular, and so that in working out what the terms of a contract are, we need to be able to identify the difference between a representation that was merely something that was said between the parties before they started and a representation that was intended to be a term. And we'll particularly go on and address that in the terms of written-only agreements in the context of the parole evidence rule. But for now, we're still just going back and trying to identify what things did the parties say to each other or put in writing to each other that might be terms of the contract. So where we're up to is talking about the relevance of the form the agreement takes itself. So key case here is the Glengallen and what is it called? Equiscorp. I think they just make these words up to make it hard for me to say them. Equiscorp and Glengallen. So this is actually it's a investment case. We've got a number of investors who've entered into some written loan agreements to borrow some money. And then some court proceedings were brought against them to recover the amounts that they'd borrowed, and they defended the action by trying to rely on some negotiations, some oral promises that had been made. So effectively what's happened is somebody's lent these people money, these people haven't paid it back, they've gone into negotiations for how they're going to get around this, whether they're going to reach some sort of agreement in relation to the new loan terms. They've potentially reached some oral agreement, but then subsequently they've entered into a written agreement that was different. They then haven't paid the money back anyway, and so the lender by this stage is just sick of it all and has sued them. So I think that might have been Scott trying to come in and out. We'll talk to him when he gets here. Could have been someone else though. So effectively what this case does is it's authority for this principle that a statement that you make during negotiations but then is not reflected in the written document is unlikely to be a representation that is a term. Because if you intended it to be binding and then you put it in a written document, you would put it in the written document. If you didn't intend it to be binding, or if you didn't in fact reach agreement in relation to it, would be omitted from the document that you put together to reflect the terms. So part of the judgment, so it's a judgment actually of Chief Justice Gleeson and then Justices McHugh, Kirby, Hayne and Callaghan. So we've got 5 judges, High Court judges, all in agreement on this. And they've said, have I got the direct quote in there? It's dealt with in your casebook in chapter 12 at paragraph 185. For an oral statement to be binding as a term of the parties' contract, the statement must have been made as a promise and intended by the parties to be of a part of their contractual agreement. So, and this is completely consistent with what we've always spoken about in relation to intention. So if the parties have written it down and they haven't included it, then there is, on an objective basis, no way for the court to know that they have in fact reached agreement on that point. And I guess that's the statement that we tend to use, or I tend to use, it's not done until it's all done. That unless all of the terms are agreed, then the contract itself isn't agreed. That the intention in negotiations is often, I'll give you something, I'll take something back. But if you don't agree to that exchange, then we haven't agreed all of the terms. And so even though one party might concede something during a negotiation, it doesn't necessarily mean that that is a done deal. It's only when all of the terms are agreed, particularly when it's put in writing, that we know what all the terms are. Even so, another important case here, which we have actually mentioned in passing a couple of times, is Lestrange and Graucob. So this is an oldish case, 1934 UK case. And this is quite consistent with, well, everything that we've been speaking about so far in relation to intention and writing. So Mrs. Lestrange had a cafe and she wanted to put a vending machine in the cafe. So this is, you know, one of those boxes, we've got them in the law school and other places around uni. In our case, they usually sell junk food or increasingly annoying healthy food. But in this case, it was actually a cigarette vending machine. So people could buy their cigarettes from this machine. And so Graucob manufactured and they sold these machines. Basically, she filled in a standard order form, and when the machine was delivered, she was asked to sign this document. Now, I think it may have actually had the term sale agreement on it somewhere. It doesn't on my slide. But basically, she was asked to sign this document. And it had hidden away in the small print a disclaimer or a limitation clause. So let me just have a look, see if I can magnify it a bit for you. So blah, 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 any express or implied condition, statement or warranty, statutory or otherwise not stated in this document is excluded from the agreement that the parties have. So she was asked to, and she did sign this document. Subsequently, it turned out that, actually she was also given a copy of it to keep. And subsequently, it turned out that the vending machine didn't work. So she went and said, you sold me a dud, you need to fix it or replace it. And they said, hang on a minute, look at the contract terms. It includes this little beauty here, which says you take it as is. We don't have to do anything. Now, remember, this is 1934. It's before any equivalent of the Trade Practices Act or the Competition and Consumer Act. And so they had an argument in contract that this private law had been created between the purchaser and Graucob, which meant that even if Graucob's machine didn't work, too bad, so sad, they can't do anything. So the question didn't become, is that an enforceable condition? Now, and that is what the question would be today, and the answer would be no, because the Australian consumer law and the equivalents in the UK as well would say you can't do this, you can't exclude the way the law works in a contract. But all that aside, so that the question in this case wasn't whether it was an enforceable term, but whether in fact the document represented a contract, particularly because Mrs. Lestrange didn't actually read the document. She just signed it. She thought it might have been a delivery form. So the issue before the court was, can an exclusion clause operate even where Lestrange wasn't aware that the term existed? And ultimately, I've got it in my notes here. Actually, I'll put in, the note that I have is from this discussion in Lord Scrutton's judgment, which is in your casebook as well. When a document containing contractual terms is signed, then in the absence of fraud, or I will add misrepresentation, The party signing it is bound, and it is wholly immaterial whether he has read the document or not. So this is what we refer to as the rule in Lestrange and Graucob. And we've talked about it using a more recent modern Australian case, the one Mrs. Chong and Fitness First, Chong and Fitness First, or Fitness First and Chong, I think it is actually, where you'll remember Mrs. Chong signed up to her New Year's Eve resolution, gym membership, didn't use it, sought to come out early, was then told she had to pay a minimum amount of money. She said, oh, I didn't know that, I didn't read it on the document. And again, too bad, so sad. You were given a document, the clauses in it are enforceable. If you didn't read it, that's your problem. And that's the way it works. So we call that the rule in Lestrange and Graucob. And in an Australian sense, that's been reaffirmed beyond any doubt in a 2004 case that you will come across quite often. So that's the Toll and Alfapharm case, which when we finish up today, I'll talk about that quite a bit. But from that case comes this, again, I think this is a full court decision or from the full court judgment. To sign a document known and intended to affect legal relations is an act which itself ordinarily conveys a representation to a reasonable reader of the document. The representation is that the person who signs either has read and approved the contents of the document or is willing to take the chance of being bound by those contents, whatever they may be. So this is this strange part of intention, where intention can be found as a consequence of the signing of a document. So if there is a term in a document that looks like a contract, smells like a contract, purports to be a contract, and the parties have signed it, there is no argument that they didn't know it was a contract or that they didn't know that that term was in it. That it becomes the responsibility of a person signing a document to know what's in there. Something I'm sure on a daily basis you do stop everything and read the terms and conditions that are given to you to sign. I'll leave that at that. So what else do we want to talk about in the rule? So the rule applies to contracts that are signed by electronic means, so whether that's by email or over the internet. And the justification behind it is that by signing it, you are representing that you are prepared to either agree with those terms or, as the judge has so eloquently said, take the risk that the terms suit you. Sorry, that's my dog. So it is a person's responsibility to ensure that they are satisfied with the terms, that the terms in a written document reflect the agreement that they intend to make. And it wouldn't be contract law if we didn't have some exceptions. So where the contract or the document that is signed doesn't actually look like a contract, that it's not understood to be a contract, then this rule won't apply in that circumstance. So we'll have a look at some options in relation to that in a second. And then the other exceptions are where a signatory's consent has been vitiated in some way. So vitiated here means that it's been broken or damaged, that effectively that they have either been misled, and remember those words earlier, in the absence of fraud or misrepresentation, that they've been misled or that there's been some kind of fraud. And so we'll talk about Kurtis in a second as well. Okay, any questions, concerns, frustrations there? I'm looking at a sea of black. So I can't read your body language at all. So you just have to break in. Okay, terms incorporated by notice. Let's go on and talk about Kurtis and Chemical Cleaning and Dyeing Company. I think I said last week, by the time we're finished here, none of you are going to want to use dry cleaners, go in parking lots, buy tickets on cruises. So I think this is the first of our dry cleaning cases. So Mrs. Kurtis took her white satin wedding dress to the Chemical Cleaning and Dyeing Company for dry cleaning. I always just want to stop there. Like, would you take something to a place to get it cleaned when they're called chemical cleaning and dyeing? I don't know, it just doesn't feel right to me. But anyway, and when she got in there, she was handed a piece of paper that had on the top of it the words receipt. The shop assistant gave it to her and asked her to sign it. So Mrs. Kurtis, clearly no naive young bride was she said, "Why do I need to sign this?" So she was told, the shop assistant said to her, "Well, it's because they can't take the risk in relation to all things, and that the shop would not accept responsibility for certain kinds of risks, in particular the risk of damage to the beads or the sequins on the dress." So she thought that was fair enough, and she signed it. Oh, sorry, a little bit behind on my little animation and my storytelling here. But in fact, the receipt itself had a much broader provision in it. It said, "This or these articles are accepted on condition that the company is not liable for any damage howsoever arising." So much broader than just the sequins or the beads or things like that on the dress. Probably no surprise, seeing we end up in the court, that the dress was in fact damaged. And so the issue before the court became, can the dry cleaning shop incorporate the receipt as an exclusion clause? So can that clause, that express term, be part of the agreement between Mrs. Kurtis and the chemical cleaning and dyeing company in relation to the cleaning of the dress? And ultimately the decision was, if you sign it, at first instance, the decision was, if you sign it, you are bound. And on appeal, the court agreed with that unless the signature was obtained by fraud or misrepresentation. So failing to draw attention to the width of the exception clause created a false impression. And ultimately, in this case, the exemption clause couldn't be relied on. So in this case is authority for the proposition that if a person signs a written document knowing it to be a contract which governs the relationship between them, their signature will be evidence of their assent to the whole of the contract, including exemption clauses, unless the clause was obtained by fraud and misrepresentation. So in this case, failing to draw attention to the width of the clause created a false impression. And then a misrepresentation was also made. The misrepresentation is, we won't take liability for the sequins and the beads. Now, there was no suggestion or no evidence that was brought that this was made in any fraudulent way, that there was any malice in making that statement. It was a misunderstanding, but even so, an innocent misrepresentation is still a misrepresentation. It created a false impression. So the exemption clause could not be relied on. So the point here, which can be a little bit difficult to grab hold on, is this is not a case that says if you, that you can't include an exemption clause in a dry cleaning contract. It is a case that says you can include an exemption clause, you can include an onerous provision, but the onus will be on you to make sure that it is not misrepresented and that a false impression isn't created. So, sorry, it's gotten noisy. I was all alone here before. I'm just going to close the door. I'm really hoping somebody's cooking for me because clearly they're not cleaning up for me. So let's see. So, in the absence of a signature, oh, sorry, I thought I was going to continue on and reinforce the point that I just made. So I just want to stop for a second and just make sure everybody's comfortable or comfortable enough in relation to that last point. So I'm just going to bring up the chat. Don't know if you could see that as well. Oh, and I've just noticed, Sigrid, you've joined us on your way home. That's awesome. Okay, no questions? All right, next part of this is the extent to which an express term can be incorporated into agreement by the giving of a notice. So in the absence of an actual signature, so something that shows that a person was at least given the opportunity to be aware that terms were in a document of some sort. In the absence of that signature, can terms be incorporated into an otherwise oral contract by putting something in a notice? And whether or not they can depends on whether the notice was given before or after the contract was formed. Now that makes sense to you, I assume, because once we've got a contract, we can't add new terms to it, right? So the notice of the terms needs to be included before the contract is made. It needs to be included in the offer or included in the negotiation in some way. And even if it's included in an invitation to treat, even if technically the purchaser makes the offer, it needs to be included in some way prior to the agreement being made. And then next, whether reasonable steps were taken to bring the terms to the notice of the party to be bound. And again, this should make sense. If I'm going to incorporate something in writing into an otherwise oral contract, it's the person who needs to comply with those terms who needs to be made aware of them. So what kind of circumstances I'm talking about? The slide here has a number of different examples. So by delivering a document that has terms in it to a customer, so think about it, last time you signed up to a mobile phone contract, you probably got in the shop where you're taking physical delivery, or even online if it was being sent to you, you'll get a document that incorporates a whole lot of pieces of information at that stage. Actually, with a mobile phone, it's a bad example because you probably had to sign for it. Better example might be going to a car park, driving into a car park. As you go into the car park, there is a list of terms and conditions on a sign, usually. So examples include things like conditions of sale, things that are on signs, advertisements, brochures, dockets, tickets, receipts, online links, range of different things. So where there's no signed contract, a supplier of goods or services will still often attempt to incorporate these written terms into the contract by referring to documents that it generates containing those terms. And here I'm using document very broadly because it might be something that's online, the back of a ticket on a sign. So let me actually just use an example that will be better. First of our cruise cases, I think. So Oceanic and Faye. So this is a case about when the timing, that terms that somebody wants to incorporate into a contract, at the timing of making that disclosure. So this is a 1983 case. Mr. and Mrs. Faye decided to go on a cruise, and they booked it through a travel agent in Sydney, but their cruise was going to take them around the Greek islands. And so Oceanic Sunline Special Shipping Company, I think they're called, had produced a brochure, and the brochure was at the travel agent's office. Mr. Faye finds this, he likes it, and he decides that he's going to do this cruise. He actually was quite a cautious man. He even read all of the terms and conditions on the brochure. And the brochure itself stated that the cruises were governed by the terms and conditions that would be printed on the passenger ticket, which could be inspected at any time by going to Sunline Cruises' office. The travel agent in Sydney didn't actually have a sample ticket for them, and the Fays didn't actually take that extra step of going to Sunline Cruises' office to have a look at the ticket. So once they paid the fare, the travel agents gave the Fays an exchange order, and the Fays took that in their little plastic pouch, no doubt, on the aeroplane with them all the way to Greece, and then they showed up in Athens and they swapped the exchange order for the ticket, which would and a boarding pass, which would let them board the vessel, which in fact they boarded in Athens. So they did that, And clause 13 of the tickets, I just love it that it's clause 13, that's how I can remember it, because it's, you know, unlucky for some, had a very onerous clause on it. So it basically said, any suit against Oceanic must be brought in the courts of Greece and cannot be brought in any other jurisdiction. Now, why do I say that's onerous? The passengers live all over the world. It's probably quite a sensible thing for Oceanic to do, only the Greek legal system is not known, and I hope I'm not offending anywhere here, but I'm pretty sure that there's verifiable evidence to back this up. It's not known for its efficiency or timeliness of dealing with things. And unfortunately, the boat sank. So the Fays lost all their stuff, and Mrs. Fay was quite severely injured. So they wanted to sue. They wanted to sue Oceanic for some issues with the way that the cruise was delivered and underperforming safety and a range of different things. And they wanted to bring that suit in Australia. But in order for them to do that, Oceanic, we had to deal with whether or not they could do that, or if they had made a contractual promise that they would not. So the issues before the court were whether Clause 13 itself formed part of the contract. In order to work that out, we needed to work out when and where the contract itself was formed. So ultimately the court found that the contract was made in Sydney when the passenger paid the fare and the travel agent issued the exchange order. And so Oceanic was bound to issue the ticket in exchange for the exchange order in Athens and to take the passenger on the cruise on the terms that had been already agreed, not new terms that were going to be added in later. Sorry, I've just said what's on this slide. But in relation to the timing, they said it was too late after the original contract was made in Sydney to add in new terms. Clause 13 on the ticket couldn't alter the terms of the contract that had already been made because the Fays could not reasonably have been expected to become aware of it until they got the ticket in Athens. So it was contractually ineffective. If there had been some notice given that there was an unusual or onerous or different clause in there, that might have ended up, or probably would have ended up, with a different result. But it didn't. They weren't given any notice of that, so they were not prevented from suing in New South Wales. So what do we learn here? Notice needs to be given before the contract is formed of any provisions that you want to include in that contract. For delivered or displayed terms to form part of a contract, they must be made available to the party to be bound by those terms at a time before the contract is made. I think this rule is as simple as once a contract is made, we can't add new terms to it, okay? Because if we want to add new terms, we need new consideration for those new promises. So how does this play out in relation to an electronic environment? A party with internet contracts, sorry, I've just looked at my picture. I'm not necessarily my order that I'm saying things on the slide. With internet contracts, there's an expectation that clicking on I agree or I accept will constitute reasonable notice. Might be different if the links are broken or if there isn't actually a link, but again, those terms are being brought to your attention. Whether or not you look at them becomes a matter for you. Also, a party who has actual knowledge that a document that is delivered or a sign displayed before or at the making of a contract has contractual terms in it will be bound by those terms. We'll look at Parker in just a second, and Shoe Lane too, which is another of my favourite cases. Also, in the case of non-contractual documents, so for example, something that looks like a ticket or a voucher or a receipt or a sign, then we need reasonable notice for the terms that are on that ticket, sign, voucher, receipt to be incorporated into the contract. So let's look at Parker. I don't think Parker is actually in your casebook, but it is discussed in a couple of those cases and in the textbook itself. So Mr. Parker, this is 1877, so it's an old one. He wanted to leave his bag, or he did leave his bag, in the cloakroom of the Charing Cross railway station, which South Eastern Railway Company ran. So he deposited his bag and he paid them twopence to look after his bag, and he got a ticket. On the back of the ticket were printed words which included a clause that stated that the railway was excluded from liability if the item had a value of £10 or more. £10 or more in 1877 would have been quite a lot of money, I'm guessing. He didn't read the clause. He thought the ticket was only a receipt for his payment, but he did see that there was some writing on the back. He was a busy man around London, so he didn't take time to read it. He went back to get his bag. Lo and behold, it is missing. It had valuable contents in it, apparently worth more than 10 quid, and they were not there. So he sued. And the railway company defended itself by relying on the exemption clause. So the ticket, bag disappears. I'm not very good at pressing my buttons as I tell you the stories today. So the issue before the court was whether the railway could rely on the exemption clause contained in the ticket. Parker thought it was only a receipt. The person receiving the ticket isn't bound by the conditions on the ticket if he didn't see or know that there was any writing on the ticket. Lord Justice Mellish said a person receiving the ticket is bound by the conditions on the tickets only if they, 1, have actual knowledge that there's writing. Oh, actually, I think I've got this on the next slide. Actual knowledge that there is writing, or if they didn't actually know the writing contained conditions, but the circumstances of the delivery of the ticket was such that they could see there was writing on it, then they're being taken to being given reasonable notice. So, delivered, displayed terms are not in a document reasonably thought to be contractual in nature, then the party seeking to incorporate them needs to take reasonable steps to bring them to the notice of the other party. Again, this is why often when you are doing things like that, you will see a sign in the shop that says terms and conditions apply in some way. Please, if there's any questions as you go, my throat's still not 100%, I will welcome the relief. Next case to have a look at, Causer and Brown, another dry cleaning case. This time Mr. Causer took his wife's dress to a dry cleaning shop that Brown owned, and he was given a docket on which appeared some printed conditions, very similar to the one in Kurtis and Chemical Company. In those conditions included a limitation of the liability of the dry cleaning company. And as is the way of these things, dresses returned damage. So the question became, can Mr. Brown, who owns the dry cleaning shop, rely on the exemption clause contained in the docket? Ultimately, Chief Justice Herring said that the docket was one which might reasonably be understood to be only a voucher for customers that they would need to produce when they were collecting the dress, as opposed to a contractual document containing terms exempting a shop from liability and negligence. So the onus was on the shop to prove that the customer was aware, or ought to have been treated as being aware, that the docket was not merely a voucher or a receipt, and that it contained special contractual provisions. So the shop in this case failed to discharge the onus, the exemption clause was ineffective, and presumably Mr. Causer was in a position as a consequence to buy his wife another dress. You can see the different outcome from, well, actually same outcome, but different basis for the outcome from Kurtis and Chemical Company. So I want to continue on now and talk about, in particular, signs, the kinds of signs that we see, particularly around parking. The example I've got on the slides are all parking one, but in the back of dry cleaning shops, at the movie theatre when we go there, before you get in the Dodgem cars, before you go on a ride at a fair, signs that incorporate, in particular, onerous terms. So where a term to be incorporated is unusual or onerous, we've already established that special notice needs to be given. And we'll look at a couple more cases that support that. So Thornton and Shoe Lane is a case I quite like. So Mr. Thornton was a freelance trumpeter, and he had a gig to play with the BBC at Farringdon Hall. So he drove into the city one day, but he didn't go into the city very often, and he found a parking spot in Shoe Lane in the West End. I don't know if any of you have been to the West End of London, but it's a crazy place. Lots of buildings, very narrow streets, very hard to get around. And this sign was actually placed just outside the parking lot, but it was at an awkward angle, and it was quite difficult to see, and it wasn't in a place where you could stop or read it. And as it turned out, Mr. Thornton had never been there before. He didn't see the machine. So he drove into the car park, sorry, not the machine, the sign. He drove into the car park and he stopped at an automated ticket dispensing machine. And he got his ticket, and then he took it and he parked his car. On the ticket, which he saw but he didn't actually read, there was some small print in one corner of the ticket that said something to the effect of, this ticket is issued, This ticket is issued subject to the conditions of issue as displayed on the premises. Now, there was another sign in the premises somewhere which actually set out those same terms and conditions here, sort of complete absolution from any liability for the cars. But these were not actually visible to Mr. Thornton. He didn't actually walk past them. They included this term, all cars are parked at the owner's risk, and included another term that purported to exempt shoe lane parking from any liability arising from damage to the car or injury to people in their car park. So, as it turned out, his car was taken up to another floor by some sort of mechanical contraption. Again, this is very London. Parking is so scarce that, cars are being stacked effectively on top of each other. And he left his car there for 3 hours. He came back after doing what it is that he needed to do, playing the trumpet. So he comes back, and effectively, as they're returning his car to him from the mechanical construction, he gets hit and he gets injured. So it was quite severe, his injuries too. I shouldn't make light of them. But I will say, the first time I went to London as a lowly law student, I did go and search for this car park to just see it, because I am seriously the daggiest person you've ever met. But there you go. Anyway, it's chaos around there, but the signs are now very prominent. So shoe lane parking asserted the liability exemption condition. They said this is a term of the contract. He accepted that we would not take on any liability for his injury. So, is it a term of the contract or not? Is it enough to exclude Thornton from claiming damages in tort? Court said there are a whole heap of relevant matters here. Firstly, he'd never been there before. He hadn't seen the signs. They weren't easily visible. He had seen that there was small print, but there was nothing on it that suggested he needed to read it. And the condition purported to exempt shoe lane parking from liability, as well as for liability for damage to the car, as well as damage to the person. So it is a very broad clause. And ultimately, the court held that a customer is bound by an exempting condition if they know the ticket is subject to it, or the car park company did what was reasonably sufficient to give him notice of it. And in this case, they found that there wasn't reasonable notice of this onerous provision, that he couldn't have easily seen those terms. Sorry. So Mr. Thornton lived to play the trumpet another day. Let me give you another example of one of these. This is Interfoto. Interfoto ran a photographic transparency lending business. So these days, if you're trying to find an image or something for a PowerPoint slide or a presentation, and you're being good, you are going to go and Google in the copyright-free images, and you're going to find some image and put it on your slide. Or if you are really dedicated to the cause, you might sign up to something like stock photos or similar sort of services to buy a license to use an image. So back in the old days of printing, images needed to come on a kind of transparency that could then be printed. And Interfoto basically licensed or lent these transparencies to people so that they could use images in printed material. And so Stilletto is doing some sort of advertising campaign. They basically need some images. So they want, you know, typical Caucasian, middle-aged students at a bar. So they get 47 images that might suit that kind of purpose. And they get couriered to them in a jiffy bag, like one of those little padded envelopes. So in the jiffy bag, there was a delivery note, and the delivery note had 9 printed conditions on it. They included condition number 2. All the transparencies had to be returned within 14 days of delivery. Otherwise, a holding fee of £5 a day plus VAT would be charged for each transparency that was retained for that period of time. Once again, Stilletto had not used this service before, and nobody read the terms and conditions. About 4 weeks later, they returned the slides, and yeah, they got a big bill. So what was it? £3,783 pounds and 50 pence. So much bigger bill than they were expecting. They refused to pay, so Interfoto sued them, effectively arguing that there had been a breach of this condition. I think I'll just point out just how much money that is for. It's a very large amount of money. It was a bigger amount of money 12 months ago, but that's because of the Australian dollar pound conversion rate being slightly better than it has been for a while. So the issue here was whether that condition was sufficiently brought to Stilletto's attention so that it could be a term of the contract itself. And Justice Dillon said, if one condition in a set of printed conditions is particularly onerous or unusual, then the party seeking to enforce it needs to show, so take special steps, that the particular condition was fairly brought to the attention of the other parties. In this case, it was very onerous. That was a very high fee, and in fact, he used the word exorbitant. Nothing was done by Interfoto to bring it to Stilletto's attention, so therefore, it's not a term of the contract. It wasn't something that they could have contemplated as part of the agreement. Again, similar case here with Baltic Shipping and Dillon, another cruise case. Mrs. Dillon was younger than me and a widow. She decided to take her sad life and make it better by going on a 14-day cruise around New Zealand. This is in October 1985. So she paid for a holiday, she paid for the cruise, and she got a booking acknowledgement document. In November, she then got a booking form that stated that a contract of carriage with a shipping company will only be made at the time of issuing the tickets and subject to the conditions printed on the ticket. So no notice again that there were unusual conditions. Then in January 1986, she paid the rest of the fare. Baltic issued the ticket, and the conditions printed on the ticket include the conditions limiting the liability of the shipping company for personal liability. So she's paid at this stage as well. Sorry, let me get all my facts straight. 7th of February 1986, she set sail. Oh, sorry, yep. No, she gets the ticket first. Before she does that, she gets her ticket. On the back of the ticket, it says, we're not going to be liable for any personal injury that you suffer. A fairly onerous provision. 7th of February, she set sail. 16th of February, the ship sank. Very sad. Mrs. Dillon lived to sail another day, but suffered some injuries and loss of luggage, etc. She sued in damages for the losses, and the issue became whether these unusual conditions on the ticket were incorporated in the contract of carriage or not. So this is the New South Wales Court of Appeal, a decision of Justice Kirby. He said, a shipping company has a responsibility to bring unusual conditions to the notice of the passengers before they can be bound by them. They didn't do that in this case. That makes it difficult for them. There were unusual conditions. She was entitled in law to the view that she would be issued with a ticket which wouldn't contain any additional or unusual provisions other than what she'd already been told about. She wasn't given any notice of anything different. Because these limitation of liability conditions were of such an unusual nature, they needed to be brought to her attention, and they hadn't taken any adequate steps to do it. So she was able to sue them in tort for negligence because they were unable to exclude that. Another thing that is relevant here is, and you've noticed I pointed out on a couple of these cases as we've been talking about them so far, that there had been, it was the first time that Mr. Thornton had parked at Shoe Lane. It was the first time that they'd used a particular dry cleaner, first time that they parked in that particular space. So let's look at what difference it makes when you are a regular customer or you know how things work. Contractual terms of earlier transactions may in fact be incorporated into a subsequent contract based on the history of or dealings that the parties have had. Let me just run through the example. You've probably come across this case in torts as well, or if you haven't done torts yet, you will, where you look at a much broader set of issues. But one of the issues in this case is a contractual one. So Mr. Robinson was a QC of some renown in Sydney, and he thought he was very special. And he would catch the ferry every day from Balmain to Circular Quay. And over the entrance to the wharf, there's a big sign that said, a fare of 1 penny must be paid by all persons entering or leaving the wharf, no exception, whether you've travelled or not. So effectively, the way that it worked as a traffic control mechanism is when you catch the ferry at Balmain, you give them a penny. When you get to Circular Quay, you're let out free, like with no charge. You can get on for no charge at Circular Quay, and when you get off at the other end, you pay a penny. So your trip is a penny either way. That's how it worked. But it was very clear on this sign, no exceptions, that whether you had travelled or not, you would be charged. So one day, Mr. Robinson runs onto the pier. He's trying to catch his ferry, but he's too late. It has disappeared. So he's trying to get back through the turnstiles. And he says, I've missed the ferry, I want to leave. They say, yeah, sure, that's fine. You've been here lots of times. Give us a penny. And he refuses to do so. So is he contractually bound or not? Justice O'Connor held that Robinson was bound by the term of the contract requiring the payment of a penny to leave the wharf. Because he travelled on so many occasions, and he'd paid his fare so many times, he'd entered the wharf with knowledge of the terms by which the ferry company conducted its business. It didn't matter whether or not he had read the terms that time. It did matter that he had done it many times. So this case also can be found in the case book. So this is Rinaldi and Patroni, I should say, and Precision Mouldings, 1986 UK case. In this case, the appellants provided some transportation services for goods. The parties had plenty of previous dealings, performing the same services under the contract 9 or 10 times from memory. In every previous dealing, something called a cart note containing the price, but also the terms and conditions on the reverse side was given. And the conditions each time included condition 5, which said that the appellants, Rinaldi and Patroni couldn't be sued in negligence for anything done to them or their associates, by them or their associates. So the court noted that for documents to be considered a course of dealing, they needed to be reasonably considered as contractual in nature. The cart notes in this case weren't that. So the previous use of them couldn't amount to previous dealings in a way which allows for incorporation of further terms. So if you're going to pull in previous dealings, you need to be able to identify the contractual nature of those previous dealings. So we're on the home straight now. Toll and Alfapharm. Now, I guess it's the last case I want to finish on, but this is an important case and it gets cited a lot in a lot of contexts. So I'm going to just make sure we're all on the same page about what happened because the facts are a little bit complex. So Alfapharm is a company that distributes flu vaccines. It does it as a distributor for a manufacturer, which is called EB, basically. Alfapharm has a contract with Toll or Findmore, as they were actually called, but it's Toll Holdings, to collect, deliver and store at the correct temperature these flu vaccines. Toll gave a cover letter with a quote stating that the services are subject to conditions on a consignment note. However, they never actually provided that consignment note. And then the representatives of the main distributor signed a credit application which included conditions of contract on the back, and nobody read these either. So we've basically got a swapping of documents, nobody's reading them, everybody's subcontracting to someone else, so it's quite complex. Oh, sorry, I'm just still needing the tea when I talk so much. Oh, sorry about that. I've just got some notes here about the provisions. So this the conditions of contract. The condition of contract for the credit application included a couple of clauses, in particular clause 5 here, where it said that EB, so the head contractor, entered into the contract on its own behalf and as an agent for the associates, so for Alfapharm as well. And clause 6 said that Toll would not be held responsible for the loss or damage of the goods. So ultimately, the question became, because you probably worked it out by now, but the flu vaccines, they weren't kept at the right temperature, they became unusable, so they had to be thrown away. That's a significant cost. So the question became whether conditions that were attached to an application for credit that weren't read, could they be part of a contractual document? And if so, what would the basis for that be? So the analysis went as follows. On the question of whether there was acceptance, so was that document an offer that had been accepted, the court found it didn't matter that the representative didn't read the contract. Signing it is a way of indicating that he read it and accepted it. Intention and acceptance are measured objectively. So in other words, the rule in Lestrange and Graucob holds in Australia. Doesn't matter whether you read it or not. If you sign the contract, then that is a demonstration that you expect to be bound by it, or you're taking the risk. Next, in relation to the issues that arose, the privity issues, because what we had here is representatives and agents effectively creating contracts for parties higher up in the chain. The evidence showed that the representative that EB had appointed and the agent of Alfapharm were authorised by Alfapharm to contract with Findmores or Toll and to agree on standard terms and conditions of the contract. So long as the terms were within Findmore's standard terms and conditions, then the representative was acting within authority. The agent relationship means that the principal will be bound by the agreement. So this is one of those exceptions that the chapter talks about in relation to privity, that even though I'm the one who signed the contract, the person that I'm acting as an agent for will be bound by that contract because I have signed as their agent. assuming that I've signed within my authority and that there is no reason for the other party to not know that my authority has been revoked in some way. So what's the effect of a signature in this contract or in this context? Legal instruments of various kinds take their efficacy from the signature or from their execution. So that could, in the terms of electronic documents, even mean their exchange. Such instruments are often signed by people who have not read or understood all of the terms, but who are nevertheless committed to those terms by the act of actually signing them. It is a commitment which enables third parties to assume the legal efficacy of the instrument. To undermine that assumption would cause serious mischief. Don't you love the way they write? Serious mischief. Sounds like little elves running around Westeros or something or other, as opposed to serious documents. But, you know, all jokes aside, there would be chaos if every time a document was signed, you could only rely on it if the person who was signing it had read it, and that you had absolutely confirmed, you know, through some blockchain register or whatever, that the person who was signing it was in fact authorized to do so. At risk of one aside too many, because we are getting towards the end here, one of the principals, partners I worked for when I was a very junior lawyer back in the 80s would always do is put a typo somewhere in the middle of the document. He was a Douglas Adams fan, so it was usually on page 42. It was his own joke. He'd purposely put a typo in there, bring it to the attention of the parties when they were signing, so that everybody would need to initial that page, so that if there was ever a dispute, he could point to the fact that they had initialed this variation as evidence that they had seen the document and that they were intended to, you know, that there was some more evidence of their intention to be bound. The next question that we need to address in this context, this is why this is a good case, because it really looks at all of them, is there reasonably sufficient notice? A person who signs a contractual document without reading it is bound by its terms only if the other party has done what is reasonably sufficient to give notice of those terms. This should be given a narrow focus, the court said. It only applies for exclusion clause or unusual clauses. So if we're talking about something that is a consignment note or some sort of ordinary piece of paperwork, it contains clauses that are unusual, then you need to do something special to point those out. And this is one of the reasons why when you walk into a dry cleaning shop, usually within the eye of sight, you will see a sign that will have some bold provisions on it that say, we don't take responsibility for these things. Oh, and there we go. That is all I want to say. But I bet it's not all you want to say. Any questions, concerns, frustrations, including at the 11th hour, questions about your assignment, if any of you have them. Also happy to stay for a few minutes to deal with any of you offline if you want to do that. Everybody's being quiet. Okay, text me if you want to talk to me. Sigrid, you travel safe home. We've missed you. The rest of you, hang in there. We're going into week 10, only 3 more to go. Only 2 more with content, and then it'll all be about revision. Okay, see you later, people.